Good afternoon, ladies and gentlemen. Welcome to my new legal podcast. I've just finished court for the day, and it's occurred to me that I should be sharing a lot more of the experience and arguably legal wisdom that I've developed over the years of working in the courts and in criminal matters and legal disputes generally. I think it's of assistance to normal members of the public and especially young and upcoming junior lawyers who would possibly benefit from this advice. Or it's not advice, it's shared wisdom perhaps. A very important topic, a prickly sort of on the cusp of being controversial topic. Today I want to talk about disqualification of judges from hearing matters on the basis of apprehended bias. Yeah, you heard that right. It's a pretty prickly topic. When you make an application for the judge or judicial officer to disqualify themselves from hearing a topic. It's also known as an application for recusal, and it's based on a case that apprehended bias arises. Now, very quickly, the application can be made orally on your feet in court. You don't need a written motion to be filed, although that can be done. And secondly, the all-important legal test. The legal test required is pretty straightforward. It's called the double might test. So the question is this: you have to ask whether a fair-minded lay observer, so a lay observer is basically an ordinary person who's not a lawyer, whether a fair-minded lay observer might apprehend that the judge or judicial officer hearing the matter, based on what's occurred, might not bring an impartial or unprejudiced mind to the resolution of the factual or legal dispute that the judge is required to consider. That's the test. Very important that you're aware of that, because at the end of the day, when you're running matters on behalf of clients, you're trying to protect your client's interests, and if there is that apprehension, or you consider that apprehension arises, you would have to advise your client on that option. Now, it's up to your client whether they wish for that application to be made ultimately. So it's ultimately a matter for your client to give you instructions as to whether they want you to make that application. Ultimately, a judgment is required to be made on the part of yourself and your client. And I hope that's of assistance, ladies and gentlemen. Hopefully there'll be more to come in future. Have a great day.